Back child support in Illinois. When a parent falls behind on child support payments in Illinois, the owed amount doesn't just vanish, it becomes a legal and financial issue with serious consequences. Whether you're the parent who is owed child support or the one who owes it, understanding your rights and obligations is crucial to navigating these situations. When parents are no longer together and no formal agreement is in place that waives child support, one parent typically becomes the obliger. This obligation doesn't necessarily start with a court order, it can exist even without one. For instance, Illinois courts can award retroactive child support whether or not a prior order exists, based on the court's discretion and fairness. Legal obligations and enforcement. Under Illinois law, back child support is enforceable like any money judgment. It accrues interest at 9%, and each missed payment becomes its own collectible judgment. Illinois statutes allow enforcement through wage garnishment, liens, or even civil contempt. If a parent fails to pay, the other parent or the state's attorney can file a petition to hold them in contempt. This can lead to jail time if a purge payment isn't made. Illinois law provides that a delinquency exists when a payment under a support order becomes due and remains unpaid. The law requires that at least 20% of the current support amount be added to any delinquency payment plan. If a child support order is in place, it's presumed enforceable even after the child turns 18 or 19, provided they haven't graduated from high school. How far back can you go for child support in Illinois? There is no firm expiration date on child support judgments. By law, they can be revived up to 20 years after each payment was due. And in some cases, support can be enforced indefinitely. If you are owed back support from years ago, as long as one payment was missed within the last 20 years, you may still be able to collect. Retroactive child support can go back to the child's birth, especially if the parents were never married or never lived together. Courts will look at several factors including prior willingness to support the child, financial ability, and whether the parent knew about the child. Understanding the process. If child support has not been formally established, and you're seeking past payments, the court will determine the amount based on past income, even if that information isn't provided initially. A lawyer can help present the correct financial information to the court, or you may risk having the amount calculated based on current income instead. The Illinois Parentage Act allows the court to backdate support before the commencement of an action. For married couples, support can typically only be awarded retroactively to the date of filing a petition. In cases where a spouse actively avoids being served, back support may still be ordered prior to service. If a parent fails to disclose changes in income, the court may issue retroactive obligations based on what should have been paid. Attorneys familiar with Illinois family law can present or defend these claims effectively, particularly in ongoing proceedings. Whether you're the parent receiving or paying child support, the law in Illinois provides tools for enforcement and fairness. Back child support is not just a debt, it's a legal responsibility. Courts can consider settlements if both parties agree, but any such agreement must be documented and filed in court to be enforceable. A law firm can assist in formalizing these agreements, ensuring all rights are preserved. If you have questions about back child support in Illinois, contact the law office of Russell D. Knight at 773-334-6311 or visit them at 1165 North Clark Street, number 700, Chicago, Illinois, 60610, United States.